remember, the definitions of who will be covered by this legislation are directly going to be linked to what's happening in the telecommunications review code, right? So at the end of the day, we still don't really know because that's still a moving target to some extent. But we have a general understanding of who will be falling in there. However, there are still some areas right now, depending on when you see both are still draft pieces of legislation, where there is some differences. A perfect example is the concept where communications is an ancillary service. When the Commission proposed the telco review, they did not actually fall within the scope. However, for e-privacy, they do fall in the scope. And that actually is leading to a lot of questions from our national trade associations. A lot of our SMEs are wondering, okay, I mean, how does this work? Why is the Commission proposing one piece of legislation one way and proposing another piece of legislation another way? Another area that continues to raise some eyebrows from some of our membership is, does this or does this not apply to machine-to-machine communication and IoT connections? Is this only really about machines communicating across a publicly available network, which would essentially be like the e-privacy today, or is this different? And the reason why this raises a lot of questions is the way this is phrased and how you can go about actually accessing that communication. And it's totally based on consent. And consent works in some instances, and it's not something that our members are against. I mean, consent is a legal basis that's available in GDPR. It's something that's available under the 1995 Directive. It's something that they've been dealing with for a long time. But when you start talking about how does consent work in an IoT sphere, especially when you're talking about an enterprise IoT area where it's two sensors communicating information to each other. And if for some reason we're talking about something beyond a publicly available network and you need to access that communication for whatever reason it may be, and there's no exemption for network and information security reasons, how do you go about getting that consent, not only from one, but both end users, especially if there's no human interface on this IoT device? Now, we've heard some mixed signals from the Commission and from some people about how they interpret it, and maybe it'll be fixed all at the end. But the question right now is this raises more potential problems than provides solutions, right? Now, when we talk further about this concept of, how am I doing here on time? Am I okay?
No, you're okay.
I'm all right. So I'll raise another I'll raise one other thing, and then we'll sort of move forward. One area where I think the Commission has sort of been trying to use an example to make people think about how do we apply the offline world to the online world. So essentially what the Commission is thinking about is if I send you a letter in the mail, we want to assume that the postman or the postwoman is not going to read that message, right? And I think we can all agree on that. But maybe you have a very busy life, and maybe you have a personal assistant or a secretary, and you tell your secretary, listen, I'm getting a lot of mail every day. Can you please go ahead and I'll let you read that mail and then put on my desk only the stuff that's really important, and then I'll get to the other stuff that's important. If that secretary, if we're applying this now to the way the e-privacy is written, she would be breaking the law because she hasn't obtained my consent. So this is the issue when you start applying this both end users consent model, which is how it's written right now, in the e-privacy regulation, it makes it more difficult. So if we apply it to the online world, when we all use these new personal assistants that are coming out within our inboxes, where maybe I send a message to you and say, let's go somewhere, and then it provides, let's see how much a taxi would cost to go there or the weather. Maybe you can give consent when you actually use that personal assistant, but the personal assistant doesn't have a relationship with me. And if I'm not even using the same email platform, for example, how is it going to go about obtaining consent for myself? So these are things where we have some concerns, and it goes, as I said, beyond this discussion of cookies and advertising, which again, we'll talk about and will certainly, at least in the Parliament debate, as we've already seen, is going to be the focus. But we have to not forget about the way this is going to apply to all different types of services that will now be classified as an electronic communication service. Some of these fixes might be easy, some of them might be a little bit more difficult, but if we only talk about cookies and do not track in advertising, we're not going to take the time properly to investigate these things. And I'm sure a couple other examples can be given here by the company on the panel. But this is the way that Digital Europe is approaching it. I mean, we want to be seen as providing some solutions, not just pointing out the negatives. But at the end of the day, this is a very dense piece of legislation. The Commission has a very ambitious timeline to not only want the negotiations to be finalized by May 2018, so in 1 year, but have it apply. So companies will have to be ready to actually put all these provisions into into practice, and then if they don't, have enforcement on top of them. And when you have a 4% fine potential of your global turnover, that's a pretty tall task, especially as companies are already struggling to get that compliance in place for GDPR. So I think there needs to be a little bit of, we can all be ambitious, but kind of have a little bit of a reality check on the timing here. Well, maybe I'll stop there and then we can talk further later.
One question I'll toss out.
Sure.
while we've got you. As I recall, the paper that Digital Europe put out actually argued for there not to be a new regulation, but rather for the elements to be instead incorporated into existing laws, including the proposed European Code. You didn't actually mention that, but is it still the position?
Listen, I think it's in a perfect world, that is certainly the Digital Europe position, right? And that's something that we were telling the Commission as soon as the GDPR was over and the hints were coming that e-privacy was going. But we also want to be proactive and realistic here. I mean, if I go into every meeting and Digital Europe only publishes saying that, well, get rid of this, well, we might as well, not do any discussion on this, because it's here, it's happening, unless we can really see some core problems, and you never know. But I mean, we also want to be able to say, hey, remember, we don't think this is necessary, and that's why we think there's all these problems that are coming up. So be aware that we've already told you about this, but we do, in a perfect world, think that a lot of these provisions that overlap with GDPR could be scrapped, and those that still exist could very easily be folded into the telecommunications code, and that same right to confidential communications can still be protected, which is something that all our members agree about. I mean, I'm a citizen too, right? I mean, I want to make sure my communications are protective and confidential. But I use OTT services not because I think there's some European law connecting it. I do it based on the technology that they provide.
Okay. So thank you very much for that. And why don't we move on to our second speaker, and that'll be Nicholas Blades, who's Director of Regulation, Competition, and Data Policy at Telefonica. And with that, you have the floor.
Thank you very much. So Telefonica is present in 3 European countries. That's Spain, Germany, and the UK. So the proposal may well apply in Spain and Germany. Question mark on the timing, whether it would apply still to the UK. We're already subject to the e-privacy directive and the GDPR, and we were calling for a review of the legislation, principally to ensure that there was a level playing field between those competitors who fall within the scope of e-privacy and those who did not at the time. And like all companies, we generate an awful lot of data, and we're becoming more and more data-driven. Not least, the way we route telephone calls and the way we route data requires us to actually look at the metadata of customers' communications. And one of my colleagues was telling me earlier that there have been some proposals to require both the A party and the B party in old telecom speak to provide consent for the metadata even to be read. Well, in those circumstances, we don't have a phone network, because if I'm calling from Telefonica to Vodafone, it's Vodafone's customer who would need to provide consent for Telefonica to send them a phone call, and that's just not going to work, okay? So we need to start thinking sensibly about how the industry actually works before making any proposals to increase the scope of regulation beyond what's already on the table. At Mobile World Congress, which is our big trade show in February, Telefonica outlined its plans to put customers in control of their data and to make it really work for them and share in the value. And those of you who have access to analyst reports might want to look at the Morgan Stanley report today that talks quite a lot about Aura, the product, and how telcos might be looking to share the value of that data with their customers going forward. We set a very high bar for ourselves in terms of privacy and consent. And so it's sort of quite a good question to ask, why would we then have concerns with there being regulation around privacy and consent? There's 2 reasons, really. Firstly, we'd actually like to use privacy as a competitive vector. So if we decide to be this private, we should gain some competitive advantage from the rest of the market if they don't want to respect customers' privacy quite so much. So there's a sort of economic reason. And the other reason is regulation has a horrible tendency to make the interaction with the customer very clunky and not be customer friendly at all. So I'd just like to talk about two questions we have about the existing proposal. So does the proposal learn the lessons of the past, or to use the jargon from the document, does it benefit from the refit analysis that's been undertaken? And I will talk about cookies, because the answer is no. So even that document identifies the fact that the cookies legislation was over-prescriptive. It created a terrible customer experience. How many times a day do you do that? Do you ever read the cookie notice? No. The only people who have benefited from the cookie legislation are the manufacturers of the little button inside the mouse whose product runs out or wears out at a much greater life cycle or shorter life cycle, and so more mouses have to be sold because people are just doing this to click through the cookie notice. Okay? So that's a piece of very bad regulation. Are we going to learn anything from it? And the answer to that, it doesn't appear to be yes at the moment. What we have is a very prescriptive consent regime, and you're going to have the same sort of regulatory failure. So we really need to avoid that. So that's the first thing we're interested in. Second question is, does the proposal pick up on best practice? So there's a lot of best practice out there in relation to privacy, not least the GDPR. So we just spent 4 years going through a privacy regime that would apply to the whole universe within Europe and is effectively becoming the global standard if you want to use any of Europe's data. So are there things that we can take from GDPR and inform the e-privacy legislation? The GDPR allows data controllers some latitude in relation to content, and also credits them with a certain amount of common sense. But that's within a very strong framework of accountability. So if data controllers make the wrong choices, they can be subject to fines. Okay? So it's not the Wild West. It's something that applies to everybody. But it strikes a balance between data controllers having perfect information about what they're going to use the data for and not overburdening the customer with a very prescriptive consent process. We need to learn from that, not discard it and start from ground zero with e-privacy. So, as we're focused on the customer and the customer experience, what could be done to make that the new piece of legislation more customer friendly? So the first thing would be to align the concept of consent for purpose or purposes, I think it says as well, with the concept of compatible further processing in GDPR. That's the way really to ensure that data can be used for the reason the customer has originally given consent and very closely aligned activities to that. So an example of that would be calling party analysis, for example, in the telecoms network. We look at calling party analysis to dimension links, how many of our customer calls are going from our network to another type of network, for example. What could be done to make, in terms of the sort of common sense element to it, we think it should really, the legislation should trust data controllers a little bit more to act in the interest of their customers and in society in general. And I'd like to use one example, and that's cybersecurity. So if there's an absolute prohibition on using information about the content of a packet without both parties' consent, cybersecurity driven from the network is going to have a real problem. So would you prefer to ensure that you receive only packets of data without malware inside, and that the network can look inside and see whether there's malware? Well, you would need both the permission of yourself and the hacker to be able to do that under the new e-privacy regime, because there isn't this common sense exemption that exists in GDPR for things that are a legitimate interest for your customer. Okay? What about critical national infrastructure? So if we see there's a big cyber attack going on, can we contact provider of critical national infrastructure who isn't our customer? Well, no, because there's an absolute prohibition on providing information about things that are happening to our customers to third parties without the consent of our customer and the hacker. So, as I say, there are some lessons to be learned from previous pieces of legislation, and it would be really useful if we could learn them through the process of adopting this piece, this regulation.
Well, thank you. So here I'll use, I guess, moderator's privilege for a second. As far as the existing e-privacy directive, as Nicholas was just saying, it includes these cookie rules. You've all seen the little pop-ups, we use cookies, please click here to accept them. How many people in the room, I'd like to see a show of hands, how many people think that these rules have contributed in a positive way to the sum total of human happiness in Europe? Could I see a show of hands? Let it be recorded, we do have one hand. Okay, so in any case, I think many would argue that this was one of many respects in which the directive was ripe for some rethinking. I think a fair point. I should add, by the way, I've asked Professor Orsky Professor Linsky, excuse me, to speak last because I thought the academic perspective in wrap-up would be useful. With that said, I'd like to hand the floor over to Jeremy Rollison from Microsoft. And again, you've got 10 minutes.
Okay. I don't think I'll need all 10 minutes. I think I'll echo some of the points that were made earlier. Listen, at Microsoft, we'll be captured in the scope of this, obviously, with a number of our services and products. I think we're still a bit in question mode because many of the provisions that were highlighted earlier and some of the more problematic aspects of this, potentially are just questions of different interpretations. I think the text as written has raised a lot of concerns if it were to become law as written, because there are some areas that I think do need to be clarified, and I can't imagine that the intention was what the letter of the text would maybe indicate. I can't imagine that this proposal would require the consent of the spammer for a spam filter to work appropriately. I'm pretty optimistic that we'll see improvements along those lines. So just to kick off, I think, listen, we're not interested in selling any products to our customers that don't come with a guarantee of confidentiality. I think all of our communications products in particular, and I think even some of the efforts we've made in the US around law enforcement access to data in particular, demonstrates some of that commitment that we want to make. And I think some of the competitive edge that you described earlier, I think we see it very similarly. So protecting the fundamental right to confidentiality is no disagreements there. I think how you interpret confidentiality and intercept is where we start to see the text become a little bit problematic. I think the idea that you would require all end users' consent for access to communications it just means that there won't be a lot of features that I think we've all seen to become commonplace. I think that is an example of where this would even go beyond the offline environment, similar to the example Alex described, but similar to the example in the European Parliament here. We all know most assistants check their MEP's email. I don't think everyone emailing those MEP addresses would ever be able to provide a consent for that assistant to actually have access to the content of that communications, and I don't think anyone expects it to. But if we look at the text as written, there would be that expectation in an offline, in an online context for what is mostly automated access to communications content. I think at the end of the day, there are a lot of services that do require access to communications to function. I don't think it's unreasonable to ask for the user's consent for those features. I think that can generally be accommodated. We're rolling out increasing amounts of personal assistant software and functionalities that, you're communicating with somebody, and if you consent, we can provide suggestions of, ways to get there more quickly, what traffic might look like, what the weather might look like. We can populate your calendar with this. But again, if you needed the consent of the airline who's emailing you your reservation to be able for Microsoft to access the content of that communications, I don't understand how that third-party aspect would be accommodated. So again, that's a question to see where we can get more clarity. Another issue that I think would be helpful to understand and potentially move the debate to a more workable space is, the expectation here is that for anything to constitute communications data, you'll need consent, right? But are we talking about data in transit, or are we talking about communications data wherever it may be? So at the terminal level, my inbox, or even we take a connected fridge example, since to answer Alex's question, this does apply to IoT and machine to machine. Well, I could understand e-privacy applying to the transmission and the communications between those two devices or between those two terminals, but GDPR applying at the terminal level itself. Is that the intention here, or is it that communications content is communications content and would be subject to e-privacy, whether it's in my inbox or wherever it may be? Then we come back to the personal assistant example that we saw earlier. So that's another area of clarity that we'd like to know a little bit more about before we raise too many arguments about how to improve it. I think that would at least move it to a more workable space. You mentioned the cookies earlier. I think, regardless of advertising models or anything like that, I mean, we operate a browser, and there's a lot of browser manufacturers, and this would go beyond browsers. This would go to any pieces of software that would provide such connections. So there are tools that already exist that prohibit the dropping of cookies, and you can even prohibit third-party cookies. But we don't have a tool yet that would say you can prohibit bad cookies but let in all the good cookies. So again, clarity as to what the expectation is around these settings and what's deemed sufficient. That's another area that I think once we have an understanding of what the intention is and where we can get clarity, we can have some more workable discussions probably too. And then finally, a point that hasn't been raised yet, there are some concerns. I sort of started out by saying the fact that we've taken such a large scope and the number of services now that'll fall into this, everything from Microsoft Skype service to your Tinder application and the communications that occur there, all of this will be in. So there's going to be a lot of different models that are raising a lot of different questions. And a lot of these models are also now going to be subject for the first time to requirements under Article 11 for law enforcement requests for access. I think it would be a bit ironic if a proposal aimed at ensuring confidentiality makes it even easier for law enforcement to have access to that communications content. So we'd like to see some clarity or potentially some additional safeguards around that provision to know under what circumstances law enforcement can put forward those requests, what form they should take, and how that would operate, particularly in a cross-border context where many of these new applications and services that fall into scope may not have a presence in Europe, or they may only be present in one member state. So that's one of the final points. And I think very broadly, we're hard at work right now preparing compliance for GDPR. And one of the things that this does, I think regardless of where you fall on the spectrum, you can appreciate the fact and acknowledge that this is a lot to digest over the next couple of years. I think we have over 300 people internally who are preparing GDPR compliance, and we have a much, much larger footprint than many other companies, so that explains some of the resources we need to do that. But some of the decisions that we have to make in that context, particularly about legal bases for processing, some of which is now, we got a message recently from Article 29, who are looking at guidance documents around consent in the context of GDPR, where we saw a very clear message, or we're told that there's a very clear message that you should be looking at other legal bases for processing, particularly legitimate interest. Okay, we're doing that. But now anything that is communications data, that's going to need to fall under a consent basis. Well, that disrupts some of the planning that you may be making for your GDPR compliance without knowing where e-privacy is ultimately going to land. So I can appreciate the idea of making all of this apply at the same time, but until we know where this ultimately lands and until we get some answers to those questions that I raised earlier about what provisions mean what, you can appreciate the difficult job of those who are trying to ensure compliance and ensure that they're not amongst the first ones to be fined with some of the big fines that are now possible. So these are a lot of outstanding questions that everyone would probably have different priority on depending on what your model is. But because we've taken such a large scope to this, and even applications and services with only an ancillary messaging feature fall into scope of this, this is going to take a lot of time to specify and tease out a little bit to know exactly how your model is going to be impacted, particularly when I think a lot of people are still raising questions about how their models are going to be impacted by GDPR. So it's a lot to digest, and I think we could just benefit and have a lot more. I'm optimistic that we can move into very workable discussions, because I can't imagine the intent is what some of the more problematic examples might seem to indicate. So I'm a little optimistic. But.
Cautious optimism is what I think I heard. Good. Thanks. So actually, that suggests a question, but I think I'd like to direct this one first to Professor Orlinsky, that's suggested by what we just heard. So really, it has to do with the question of areas where there's overlap between the new privacy regulation and the GDPR. My understanding is, in this context, that the new privacy regulation would be treated as lex specialis, whereas relative to the GDPR, lex generalis. That means that because the new regulation is more specific than the GDPR, it would take precedence in those areas where it takes an explicit position. Is that your understanding? Am I getting this right? Non-lawyer?
Yes, that would be absolutely my understanding. But I do agree with some of the points that have been made by previous speakers. For instance, the point that's just been made there by Jeremy about the lack of clarity regarding the scope of the e-privacy directive. So are we talking here about data in transit or data held at the terminal equipment or at end devices? So is that within the scope of the e-privacy, or is that within the scope of the GDPR? So it might be helpful to have things like that clarified in the recitals of the e-privacy directive. But on that issue of the relationship between the e-privacy directive and the GDPR, so I guess I should start by saying that my primary area of research experience is looking at the right to data protection, its application by the Court of Justice, and then the foundations of EU data protection law. And I think actually, trying to make an academic connection here, you can see that the debate on the e-privacy directive very much reflects one of the central tensions in EU data protection regulation, which is that on the one hand, it is kind of normatively or aspirationally driven towards individual control over personal data. And you see that very explicitly in the GDPR, in the provisions like the micro rights, in particular, the right to data portability. But while it is driven in that way from an idealistic or an aspirational perspective, that in practice leads to a lot of tensions, most notably because personal data can relate to various individuals at one time. And I think that because the e-privacy directive has really taken that idea of individual control over personal data, whereas, as Jeremy has said, in the GDPR there's an effort, while placing emphasis on control of individuals, there's been an effort to bolster that by reference to other aspects, such as the legitimate interests of the controller and accountability on the one hand, so putting more emphasis on controller control, for want of a better way of explaining it, and then also on the role of the supervisory authorities in actually enforcing data protection law. So to really kind of buttress the framework of individual control over personal data with these additional measures to make the overall framework more effective. And I think what you don't see in the e-privacy directive is in many ways that direction. So we don't have that same level of accountability for the controllers in terms of, I think Nicholas gave the example of data security issues. There, I think the only way you could really take into account data security issues if you need the consent of both end users is by relying on an Article 11 exception at member state level. So you can see there that that's where this type of thing becomes problematic. But equally, when you look at the enforcement mechanisms in the e-privacy directive, you see that some of the mechanisms provided for by the GDPR, and most notably here, I think from a civil society perspective, the GDPR provides for a very important right for collective action or representative action on behalf of data subjects in order to enforce data protection rights. And that's now entirely absent. I'm sure colleagues on the panel will be quite happy about that, but that's now entirely absent from the e-privacy regulation. So I think a lot of the problems that have been discussed here already stem from the fact that it's taking this very individual-centric approach. Now, I think it would have been good to move away from that model, but it seems we haven't. So, this being said, what are the other features of the regulation that might be talking points from a regulator perspective or a civil society perspective? Well, here, as has already been mentioned, I don't think anybody would argue that the current opt-in model for cookies has been a regulatory success. I think that's clear from the room today. Then the question is, what do you do in order to rectify that situation? Do you move away from consent? That's not what's happening. Well, then I think from an individual's perspective, you need to, again, buttress that consent, make it easier for individuals. And here, for instance, the Article 29 Data Protection Working Party has argued for a total ban on cookie walls. So the idea that you wouldn't be able to access an online service if you don't accept cookies. Now, I do appreciate the point that cookies are often, multifunctional and can serve various purposes. So there is a question about the technical logistics there. And I'm a lawyer, I'm not going to go into that. But I also think there are some other issues there. So I think it's quite helpful that in Article 10 of the regulation, that there's recognition of the role that gatekeepers can play in helping to enhance individual data protection and privacy rights. But I think, as Frederick Borghesius had kind of mentioned before the European Parliament in hearings this week, so the idea here is that you as an individual, when you first use a particular web browser after the 25th of May next year, which I agree is an ambitious timetable, that you would be given a very kind of granular choice as to what type of cookies, if any, you were willing to have placed on your terminal equipment. So this could be, for instance, no tracking at all by any cookie, no collection of data by cookies. And that this would be the browser then that would enforce that when you subsequently visit websites. So it's really enlisting the use of the browser as a privacy enhancing or a data protection enhancing technology. And that's something that privacy advocates have been very supportive of. But I do also take the point that this is very technology specific. And we're talking here about data processing in the context of internet access, whereas we've already mentioned the Internet of Things a couple of times, and it's difficult to see how that provision would be helpful in the context of direct machine-to-machine communications. So you also see there that the kind of professed technological neutrality of the regulation is not materialized in practice. But I do think this mechanism, and this goes to the European Union's and particular discussions in France and Germany on platform power, that focusing more on the systemic level at the role of gatekeepers in this context will be more useful in the long term than pushing everything back on individuals to exercise their own rights. We might also get a better balance in terms of how and when personal data can be processed as a result. Then just two other points I'd like to make very briefly. First of all, on the case for harmonisation here, well, obviously I'm not coming at this from an industry perspective. I can imagine a regulation is quite useful. I think one thing that's quite striking here is that the GDPR, even though it's a regulation, contains multiple very important exceptions that will be determined at national level. So most obvious here, I think, is the fact that it's at national level that we'll see a balance between data protection and privacy and freedom of expression. So that's entirely critical to the scope of application of the rules, and it's still going to be applied at national level. It seems to me that this regulation, and maybe colleagues would disagree, but this regulation seems to be a little bit more like a regulation in nature, insofar as it seems to leave less discretion to the member states. It also is going to embrace the architecture for enforcement that's put in place by the GDPR. So most notably, you have the creation of a European Data Protection Board, which will be able to issue binding decisions even if the lead authority, so leading the investigation of transnational data processing issues, disagrees. So this is kind of a right to override, which is quite controversial when you put it, first of all, in the context of independent data protection authorities, but equally for any of, if there are any EU law geeks in the room, if you're familiar with the Moroni Doctrine, which says that EU agencies should only be given this independent decision-making power in fields which are purely technical, I think this agency goes beyond the powers of any other EU agency insofar as data protection is a very normative field of law. And so you're giving decision-making powers to an agency in an area where everything is to be argued. And you can see that at the moment in the current clashes between, for instance, some of the German data protection authorities and the Belgian and others, and the Irish Data Protection Commissioner on how Facebook's data processing should be dealt with and whether or not it's compatible with the EU rules. So the idea that there's one definitive technical answer to that question is, I think, perhaps a stretch. And then final point, because I'm sure I've gone over my time. It's okay? Okay. So final point is just on international data transfers. So Nicholas queried, whether or not the e-privacy regulation would apply in the UK, and had mentioned, well, possibly so, because if you're looking at personal data protection as a parameter of competition between companies, we're starting to see that emerge, although because it goes to the quality of a particular product offered, and quality is such a kind of multifaceted element, it's very difficult for individuals to choose services simply on the basis of privacy or data protection options. I think that might be one reason why this will apply in the UK. The other obvious reason why this might apply in the UK is because of adequacy. So at the moment, presuming, as it seems highly likely, that the UK will exit the EU and that will be a hard exit, then that means that the UK will become a third country for personal data processing purposes. Now, this might be hypocritical, but at the moment the UK benefits from a presumption that it offers an adequate level of protection to personal data. However, it will lose that and therefore we can have flows between the UK and other EU member states. However, once it steps outside of the EU, it will lose that presumption, and it will need to show that it offers an essentially equivalent standard of protection for personal data in order for data flows between the UK and other EU member states to continue. Now, the current ICO, so the regulator in the UK, Elizabeth Denham, has indicated that the GDPR will be enacted and will continue to apply post-Brexit. I haven't heard any indications on the e-privacy regulation, but I would say in that spirit, it seems likely it would. But the bigger issue for the UK will be that the ECJ's Schrems judgment didn't focus simply on the data processing conditions applicable to the private sector. It also looked at the state surveillance apparatus at play in the US to say that means that when data are transferred between the EU and the US, the protections offered are inadequate. Now, we have a very conclusive judgment from the European Court of Justice from December of last year, which indicates that the UK's intelligence, so the Investigatory Powers Act, well, its predecessor, so some minor changes have been made, but on the whole that the UK's intelligence framework doesn't comply with the rights to data protection and privacy. So I think the UK might be left with quite a stark choice post-Brexit as to whether or not to change the way in which it approaches state surveillance issues or to lose international data transfers. Now, the idea that there would be some sort of negotiated or political solution to that, to me, seems quite tricky because the reasoning of the Court of Justice is very much anchored in the rights to data protection and privacy, which trump any legislative or commission decision, legislative measure or commission decision. So this seems to me to be quite a difficult position for those interested in adequacy to negotiate around. But I'm sure others will have comments on that, so I'll leave it there.
I'll actually toss a comment out on that last one. It's interesting that the word that you chose was that it trumps other considerations. The solution, by the way, there's a Bruegel blog that I authored that makes almost exactly the same points. But as many of you would be aware, the Privacy Shield agreement with the US that seeks to deal with exactly the same issues was based in part on an executive order from the Obama era. And Trump's first executive order on migration basically took an almost opposite position. Obama saying that foreigners have privacy rights in the United States, Trump saying that they don't. So in any case, with that said, do you think there's any prospect for a Privacy Shield-like agreement between the EU and post-Brexit UK?
I think a lot will hang on the balance, depending on what happens to the current litigation. So we know that the Privacy Shield agreement, let's see whether or not that survives its first review. I think if you're to be true to the wording and the findings of the Court of Justice, it probably shouldn't. But at the moment, there's litigation pending before the Irish High Court, querying whether the other mechanisms to allow for international data transfers, so the more ad hoc mechanisms, such as standard contractual clauses or model contracts, for instance, or binding corporate rules, whether those mechanisms are also subject to this same rationale. And so kind of Schrems too, I guess. And all eyes are on the Irish High Court to see the Irish Data Protection Commissioner engineered that litigation post-Schrems in order to have questions about the compatibility of those mechanisms with EU rights referred to the Court of Justice. But it's unclear whether or not the Irish High Court will actually refer those questions. Now, if it doesn't, I would say it's at least possible that there would be an appeal and that would go to the Supreme Court, and if it raises a question of EU law, the Supreme Court would then be bound to refer those questions to the ECJ. And then I think that the way in which Schrems was framed by the Court of Justice just leaves it very little room for manoeuvre to not find those mechanisms incompatible with the rights to privacy and data protection. So I think a few critical judgments, Digital Rights Ireland, Schrems and Tele2, because they're so heavily anchored in the EU Charter, have really lessened the room for manoeuvre, I believe, at least.
That's pretty fascinating. Well, so a question I'll toss to the other panelists based on what Professor Linsky just said. And that is, one of the points that she raised had to do with European oversight versus member state oversight of these issues. Do you have preferences on that, and do you have a sense as to what the right position here is?
I mean, listen, in an ideal world, everyone should be interpreting the same regulation across Europe, right? So in theory, we should be coming to similar conclusions. So I like to think that we're going for the right objectives there. I think the Germans should come to the same conclusion about the applicability of a regulation that the Irish should come to. If they have plans to do otherwise, well then we are kind of threatening some of the objectives and benefits of the legal certainty and harmonization that was presented as the impetus for much of these proposals. So.
I was going to say, the Commission's impact assessment also in their consultation, lack of consistent implementation across the member states featured pretty prominently. So it's an issue. I'm sorry, you were going to say.
No, I was going to say, I mean, I agree right now when you read the e-privacy, the draft regulation, that it does have less carve-outs if you look at the final version of the GDPR. But remember that a lot of those carve-outs that were provided to the member states were coming during the legislative process where the council wanted those carve-outs put in there. So the council, as people probably are aware, I mean, they have a lot within that one telecommunications working party is dealing with a lot of other files. They won't really start looking at e-privacy until the Estonian presidency begins, but there's nothing stopping the member states from putting their general approach, having all different types of carve-outs there. So I mean, like I said, this is still a draft, it's still a moving target. We don't know. Obviously, that's not something that industry would want because the more harmonization, the better. It's certainly something that we're very concerned about with the GDPR. There are some very key provisions there that do allow member state flexibility. I know the Commission is working very diligently with the member states to do their very best to ensure as much of a harmonized approach. But I mean, at the end of the day, is it going to be 100% the same in every member state? Probably not.
Okay, I'll toss out one more question to the panel as a whole before we move on to the audience. Excuse me. Getting over a cold, gang, sorry. We've heard a lot about the potential for inconsistencies between the new regulation and the GDPR. The Commission clearly worked to eliminate clearly redundant sections, the most obvious example being the breach notification portion. But in terms of privacy as a whole, in terms of the privacy of communications, there does seem to be pretty substantial overlap. The GDPR certainly covers that. And in some cases, as we've just said, the provisions are not compatible. Are those sections really necessary? Do they actually do things that are needed that weren't already in the GDPR? Views on that?
I just think it's a function of it's one department drafting one regulation and another department drafting another piece of regulation. That's the fundamental way that government and public policy works, unfortunately. And that's why we're at the stage of saying, well, you've got these other things on the statute books that taught you some valuable lessons, and you need to sit within that framework that already exists. I think it's as simple as that, I'm afraid.
I would argue as well that some of those provisions that they said that they deleted still exist in some aspect. If you look at the article that's related to security, it doesn't require breach notification to the Data Protection Authority or to the competent authority, but it does require some type of notification to all end users about when a particular risk occurs. There's no real clarity on what a particular risk means. Again, as we discussed before, informing both end users, specifically if one of the end users is the malicious actor who is involved in the actual security incident. So there is still some type of obligation to inform somebody, and this is very much, at least in the views of Digital Europe, overlapping in some ways with not only the data breach notification requirements in GDPR, but also the breach notification requirements in the Network and Information Security Directive. And what we want to avoid is a situation where we're over-reporting all the time to these data protection authorities, because in some member states, these are very small entities. Now, of course, maybe they get more resources after their national laws are updated, but at the end of the day, companies, when they're faced with a potential 4% fine of global turnover, are going to err on the side of caution. And in many instances, that will mean more reporting than normal, just to sort of cover their backs, if we want to use that expression, similar to the way they're going to be issuing more data protection impact assessments to clarify that what is considered a high risk and where that bar lies, we will find out, but they will submit a lot of these data protection impact assessments to the competent authority, who is then required to respond to that. And that will either lead to companies waiting to put into place their data processing, and combined with the authorities being overwhelmed with large amount of administrative paperwork.
Yeah, I think concretely this is another spot where just some more clarity would be helpful. Knowing how Article 17, as Alex mentioned, in a security context, how the obligations there differ from GDPR, that would already give us a sense of where there may not be problematic overlap. And also NIS comes to mind with that too. And even Article 7 around erasure of data, how is that different, or how does that go beyond or specific to communications that the GDPR doesn't already cover? Again, this is just an area where some more clarity would be helpful.
Well, I would tend to agree that this is probably just a practical matter in terms of competences, but also a historic issue insofar as I think the e-privacy directive, the initial one served... Sorry, is it mine? No. Okay, it's not mine. I'm sorry. The e-privacy directive served a purpose at a time when the data protection directive was took up quite a principles-based approach, and therefore it really was a lex specialis. But I think one thing that's lamentable about the GDPR is that it's obviously gone for a far more prescriptive approach to the way in which it regulates personal data processing. And so while I think there is a need for some of the provisions in the e-privacy regulation, I think these could probably, given that the GDPR is a lot more prescriptive now, have been slotted in there. Insofar as a lot of, as I said, the enforcement apparatus is common to both systems, etc. So I think if you'd taken out the provisions on cookies, so Articles 5 to 8, and put them in the GDPR, they would no longer look anomalous, and you would then have one kind of piece of comprehensive legislation.
Thanks. So this has been a good exchange. We usually try to open things up for about a half hour to the audience for questions, and I'm happy to report that we are right on track. So with that, this becomes your session. If you have a question, we'll be bringing microphones around. Please identify yourself and your organization before you ask the question. Questions? Here's one.
Thank you, Jakob Renner for Deutsche Telekom. Rather a comment on the question of discretion, member state discretion. What we find very critical in this proposal is that there is still a possibility under a recital that member states can specify at national level what is written in this regulation. So it's a principle of minimal harmonization, not full harmonization, and we've seen in the GDPR that this can get critical. For example, Germany has proposed a law that might slightly deviate from the GDPR, and I think any multinational company that has several subsidiaries in Europe cannot be happy about this approach, because there will be several, maybe different laws at national level trying to specialize what is written in e-privacy.
Good. Well, let's take another question or two, and then we'll hand off to the panelists.
Thank you very much. My name is Wolfgang Pape. I'm associated here with SEPS in Brussels, formerly with the Commission. I have the feeling this is a very Anglo-Saxon panel, if I dare say so. It sounds like it, and maybe even the cultural background is like that. Being a continental European, I have the feeling there are some cultural differences, not only between Anglo-Saxon and continental European. I have been in Japan for a long time, and the idea of individual privacy is completely different. Particularly, the extreme case for me is Japan. It has very little of a history there, and they use the word privacy even as a foreign word in their language. But even within Europe, and you mentioned it, Professor, there is some difference already, UK and the rest of Europe, the 27. And I wonder how far this naturally will have an impact on implementation. It was mentioned that member states might implement these rules differently. Certainly we have that with other rules as well, but nevertheless it might be particular in this case. How far can courts, and the Court of Justice here of course is supposed to be the last instance, can have really this kind of harmonizing effect? Is that the last instance? Is there any other possibility to have that? And one other question, if I may, is there any data or estimation of the commercial value of data received from cookies? Thank you.
Those are pretty fascinating questions. We can take maybe one more, and then we'll hand off to the panel. We have one.
Thank you. Caroline Greer from Cladflare. The EDPS published the opinion yesterday in e-privacy and proposed separating the e-privacy regulation from the code. I'm just wondering what the panelists think of that idea.
You're familiar with that, I presume?
I'm familiar with the code. I haven't had a chance to go through the EDPS opinion in full yet, so I would probably want to wait for that. I would simply say that, coming back to the point about scope, the fact that that's still somewhat of an open question as negotiations on the code continue, once again, make this difficult from a compliance standpoint when you're already working towards GDPR compliance, which is definitely going to happen. We don't know when this is going to be finalized, and we don't know how many services will ultimately be captured until we do have a definitive answer on the code. So this is a moving target all along the way, which once again is a difficult spot to be in if you want to make sure that you're providing concrete instructions to engineers who have to roll out changes to all of your services to be compliant by May with GDPR and ultimately with e-privacy when that ultimately lands. So,
Tell you what, since you're on, why don't you take on the other two questions, and then we'll hand over to other panelists.
okay.
If you have anything to
Yes,
say.
there was a question about economic value of the data collected from cookies. I don't have that data. That was an easy one. The other one was the extent to which the courts would provide clarity or jurisprudence. Well, I think we want to avoid that to a degree. I mean, ideally, the text of the regulation should be clear enough. I think one of the possibilities in a GDPR context is that we're seeing the Article 29 group come out with guidance for particular aspects of GDPR. And some of that guidance can potentially look a little bit different than what the requirements of the text may be. And there's some areas of the text that are, open to a degree of interpretation. And while I think the court would have the final say and would certainly be able to provide that clarity, I certainly don't think our plan is to take this to the court. I think we want to avoid the type of investigations from DPAs that you would then have to challenge and ultimately get an answer from the court. So if the court is providing too much answers in that space, it probably tells us something about how clear the regulation was drafted in the first place. I'll stop there.
Okay, good. Why don't we go to Professor Linsky next? I think some of the other questions that we heard related to ability to respond to sort of stylistic differences among the member states. I think especially Germany as being very much a counterpoint to the UK.
Sorry,
I must say, I hadn't actually read the recital on minimum harmonisation, so I should have had more coffee before reading the regulation. But I would agree that that would be, in my opinion, quite problematic, and also a real kind of counter-indication to the very fact that you have a regulation in the first place. So, you know, it does beg the question of whether or not this is a directive in a regulation's kind of clothing. Because, you know, in interpreting the directive, obviously the Court of Justice has been very clear that it's a maximum harmonisation instrument, and any attempt by member states to introduce other exceptions or to even make the protection stricter have been limited in that regard. This probably is a very Anglo-Saxon panel, I agree. So I guess I'm Irish but living in the UK. There is certainly no legal culture of a right to data. Well, in the UK, there's no right to privacy, and the courts have been very clear on that. So we've kind of had various torts kind of fashioned into some sort of various kind of models of privacy rights, but there's no overarching right to privacy. In Ireland, there's a constitutional right to privacy, but no culture of data protection, as is quite apparently quite obvious. But I think that just goes to the point that I was trying to make in the context of the European Data Protection Board, which is that there are very different normative starting points for the member states when looking at data protection. In some member states, like in Germany, you have decisions from 1983 on a right to informational self-determination, which itself isn't even anchored in privacy, it's a personality right. Whereas in others, as I said, like Ireland, there's just no history of a right to data protection. It's a purely compliance issue. So what you've seen is very much then a top-down approach at, and I dare mention this in the UK pre-Brexit, or in the context of those you know, that debate, but you've very much seen a top-down approach from the EU of kind of creating a right to data protection in the Charter. So it's the only international agreement with a right to data protection that's independent of a right to privacy. And I think the European Data Protection Board is going to be very interesting in that context, because particularly with the UK out of the running, I think that the balance in terms of decision making will switch more to countries where there is a history of an illegal culture of data protection. So I would actually say that will make things more strict and need for a more kind of stringent approach to data protection. And then just on the commercial value of data, obviously I have no idea there, but what I do think is quite interesting is that if you look at the GDPR provisions on consent, you see that consent will be deemed invalid inter alia if it's based on processing that's not necessary for the performance of a contract. And I really think here we might at some point see litigation or guidance on what amount of data it is reasonable for services that are provided for free at the point of access to process as consideration or compensation for those services. So you see that kind of mentioned explicitly in the recital of the regulation, that in some points or in some instances, that's an under-exaggeration, data is provided as compensation or as consideration for free services. But we've, as of yet, no indication of what's a reasonable amount of data to process. Now, in the context of Facebook audits, the Irish Data Protection Commissioner has said, you know, clearly Facebook is not a charitable organisation and it's reasonable for it to process a certain amount of data as consideration for the free service. But I think there we're likely to see quite a lot of different opinions from DPAs. And I think this is also where competition authorities might start to get involved. Is the price exploitative? Now, obviously, again, exploitation as an abuse of dominance is, you know, exploitative pricing is quite controversial, but I think that's where the Bundeskartellamt is going in the Facebook investigation. So I think we'll see a lot more focus on, and consumer protection authorities, on what is a reasonable amount of data processing as compensation or consideration for free services.
That's pretty fascinating. Okay, Nicholas, why don't you go next?
Okay, so in terms of the separation of the code from the privacy, fundamentally the two things are linked because of the scope. So unless you're going to completely take the OTTs out of scope, which is the implication, you can't delink them. I would say that in a world where people communicate by more than just telco networks, it it would look even odder than it does today that we had one set of rules for one set of communication services, which in 10 years' time might be the dominant applications. And they were not covered by privacy for what might not be the dominant applications.
Just on that point, they did clarify they were content with the scope being extended to OTD. So I think it was rather just separating from the definitions and maybe dealing with separate definitions in I don't know, some new e-privacy context.
Right. So the e-privacy regulation is actually that's one element where it's very good in that it writes the scope in a way that is inclusive, whereas sort of the telecoms code tears itself apart trying not to be inclusive, if you see what I mean. So if I were to do anything, I'd change the code, to be honest. In terms of country differences, now operating in 3 countries in Europe, I totally agree that there are some very big cultural differences in relation to data privacy, but also individual privacy. And that we see that outside of the scope of these new regulations. We see it in practice today. I've lost count of the number of times I've been asked in the UK, how do we verify customers when they get a prepay card, a prepay SIM? We don't, because we don't have in the UK a standard national form of identity. That's our protection, and that's our privacy. Whereas in Germany, where you do have a standard national ID card, your communications is private. They know who you are, but your communications is private. Whereas in the UK, they don't know who you are, but your communications maybe is more open to interception. So in all of these things, it's a balance.
It's interesting.
Yeah, I mean, I can just quickly echo what was said before. In terms of the value of the cookies, I think you might want to look more towards IAB, which is the Advertising Association. They probably have a little bit more information on that. I don't know how they go about quantifying it. I mean, if I use a practical example, I mean, our website, Digital Europe's website, we use first-party cookies, and it's simply for analytics to make sure to see how many people are coming to our website, how many people click on, when we post a news update. We don't generate any value off of that. We don't have any advertising on our webpage. So then you would say, okay, the value of that data is what, 0? But there is some data created. But another website might also use that first-party cookie for generating data, and then they might use it to, I don't know, say, okay, our website's not working, so let's create a new website, and there's obviously some sort of economic activity there. So I think, it's important to remember that data in and of itself, raw data, is very difficult to value. It's how you use the data and what you do with the data, right? But of course, maybe if you want to look at the value of third-party cookies and how that's being used, maybe they have some information there. In relation to the court providing certainty, partly that's the reason for why the court exists, but I would sort of echo what Jeremy said is, I don't think that's a practice that we would want to sort of encourage or emulate, because indeed that means, if I'm looking at it from the perspective of the Digital Europe members, their main objective is to obtain legal certainty. So the last thing that they want to do is, go through a legislative process, have the legislation in place, and then go through an entire legal process to finally get some clarity from the court and be doing that all over again. That's certainly not something that we would want to encourage or we would like to have happen. It's an important role for the court to play if that's necessary, but sort of using the court as the final judgment for providing legal clarity, I'm not sure that's the model that Europe should really sort of be pushing and moving towards. And then in relation to the EDPS opinion, again, I haven't had a chance to read it. I'd be more interested in seeing as well how they look at the definitions, because I know at least from the point of Digital Europe member companies, the way that the definitions in the actual legislation between metadata and content data, and is actually metadata viewed as high risk or not, combined with this discussion of the interplay between the scope and how that's a bit of a moving target, seeing how those work together would be a bit interesting. But at this point in time, again, anything can happen in the review process, but they're talking about things that my personal opinion would be that's not going to change. I think it's going to be linked to the code, and I don't see any indication from the council that they suddenly want to separate that process, which is why they're looking at first, let's do the code, and then we have the definitions, then we deal with the privacy. So I'm not really sure what will happen there, but I don't have really high expectations on that changing.
Well, Thank you very much. As far as time, I would say we have time for another 3 questions, and at the end I'll give the panelists, let's say a total of 5 minutes combined for closing brief statements, just so you know it's coming. So 3 questions. Yes, I see there's one in the back.
Bruno Basalisco from Copenhagen Economics. Thanks for a lot of useful food for thought. I see around the back the motto, improving economic policy. And I think today, even though we haven't used the economic concept explicitly, we have implicitly, and we have been discussing about a fundamental right. I think everyone here has agreed that this is important. And my question to the panelists is, do we have a grasp, or what are the trade-offs for us as a society in terms of the costs and benefits of different ways to achieve this fundamental right in a future-proof way? We've heard about cultural differences in cultural preferences within Europe. We've heard about different applications from machine to human interaction, and a variety of sectors and a lot of transaction costs. All of these are tricky concepts. How do we know that we're getting the balance right?
Very thoughtful question. Next. Well, I'm not seeing more hands. Why don't we rotate on that one first, and perhaps that'll suggest some more questions.
Well, we've done some work going back a long time, but looking at the ARCO rights in the existing legislation. And essentially the framework we used to analyse that was whether those rights would arise through the competitive process or not, and so whether there was an additional cost. And in general terms, we thought that there would be parties offering the ability to amend data because they want data to be better, and rectify errors because they want a better customer experience and all that sort of thing. I haven't seen any analysis to a similar degree on the new package, but that would be the framework I would use, is to look at whether you believe through the competitive process in the counterfactual that these rights would arise.
Well, I guess I would answer by reminding folks too of the fact that one of the reasons we take such an interest in this is not just for the consumer-facing services that I think usually are the examples that you hear the most about, but we're really excited about our customers in Europe, particularly our enterprise customers, large industries, medium-sized industries, small-sized industries, who are building solutions on top of some of the software and cloud computing services in particular that we're providing. So their data may be running on software or platforms that we're providing to come up with new insights and new innovations that are released then in Europe and ideally globally, and more successful the better. And I think one of the focus that we have on this proposal as well is, we're asking ourselves questions about compliance, but we're echoing many of the questions that we're getting from those smaller customers who certainly don't have the same resources in terms of legal counsel that maybe some of the larger companies have. But are we encouraging, because I've heard it in many other contexts, particularly from the Commission, how much we want to encourage and build the European data economy. I think we do have to make sure we try to get that balance right and continue to ask that question. Are elements of this proposal going to incentivize some of those smaller players that we would like to be at the forefront of the new emerging technologies around AI in particular? And AI and IoT are two instances in particular, I think, that will raise some problems with certain aspects of the e-privacy proposal. So, that's a roundabout way of trying to say that in terms of that economic impact, we have to be looking at how these proposals do stimulate growth. I don't think anybody wants to sacrifice, or anybody should sacrifice or do anything to chip away at a fundamental right to confidentiality or fundamental right to privacy. But I think the Commission would agree that we want to make sure that we're encouraging citizens across Europe to benefit from these services and to develop more and more of them.
So just a couple of comments on that. In this context, there has been a lot of discussion about whether or not a cost-benefit analysis is appropriate, given that we're talking here about the protection of, or, you know, a policy that is anchored in a fundamental right. I think it's quite interesting if you look at the GDPR, it's explicitly linked as its legal basis to Article 16 of the treaty, whereas if you look at the e-privacy regulation, rather, the proposed regulation, it's a bit more open insofar as it's linked to Article 16 plus the EU's internal market, so it's general internal market competence. So I'm not sure what you can draw from that, but I think there's always been a tension there between, on the one hand, the idea that the data protection framework is a fundamental rights framework, and then on the other hand, that originally, before we had an EU charter or a right to data protection, it was designed to ensure the free flow of personal data, which is a very economic purpose. And so I don't think you could apply a strict cost-benefit analysis in this context, while recognising, of course, that you have to somehow try and limit the costs. And I think you can see that when you look at a few of the provisions. I've been working recently on the right to data portability, and there you can see very clearly that the application of the right to data portability is entirely decoupled from economic logic. You know, if you looked at data portability from a competition law perspective, or as the Commission is doing for non-personal data, it says, well, we need to assess whether or not there'll be adverse effects for data portability. Whereas when you look at the GDPR right to data portability, it applies irrespective of whether or not, or, you know, what those economic effects are. It doesn't matter if there's dominance. It doesn't matter if it's an SME. It doesn't matter if the data is useful for switching, for instance. So I think, you know, many of these rules are decoupled from that economic logic, and that does then pose the question of how do you then stimulate growth here? And clearly the Commission believes, and I think there's something to it, that that the way forward is to have trust in digital services. Because, you know, I know just looking at some of Facebook's recent public affairs work, for instance, it's been kind of touring the world on its discussing and getting stakeholder feedback on trust in and control over user information in the digital economy, recognizing that the more users are able to equip themselves with ad blockers and various privacy enhancing technologies, the more that's problematic for companies. And so you end up with a bit of an arms race. So the better way forward here, perhaps the more sustainable way forward, would be to bring consumers with you by facilitating trust and creating kind of products that have privacy and data protection as an inbuilt feature. Now, that might be totally idealistic, but I think given that there's going to be no give in the European rules, which I think is correct, then that's the only way forward, really.
If I could toss a few of my own thoughts in here. I think that you posed a very important but very difficult question. The Commission itself, for example, they'd had an independent study done of the e-privacy directive, and more or less the opening pages lament the fact that they couldn't get any data. The opening pages of the proposed regulation itself laments that the Commission couldn't find any data. I happen to be leading a study of e-privacy in multiple non-European countries in 2008. We asked a couple of dozen experts a number of questions about privacy in general. The one to which no one gave us any answer whatsoever was the question of the value of the privacy arrangements in Europe. So I think this is one that very few people have good data on. I would also add that there's reason to think that the average consumer has difficulty valuing privacy for their own purposes. Some of the experimental economics that come from people like Acquisti suggest that this is a challenge for the consumer as well. So it's a tough problem. If you know people that are working on their PhDs, it's probably a great thesis topic if they can actually make headway on it, which I'm not sure. With that, I would say we have time maybe for one more question, if anyone has one. Well, seeing no hands, why don't I invite the panelists to make some closing statements and perhaps respond to what they think they've heard both from the other panelists and from the audience.
Yeah, sure. I mean, we have obviously had some very interesting points, and when you come to these questions about how you go about striking the right balance, it's always a tricky thing, and sometimes you don't know until the legislation is in place and a couple of years have gone by, and then you see what the problems are. I mean, I think for some of these issues, let's say, especially when it comes to the data economy, we won't find out until 10 years from now, if we're sitting here again in Brussels talking about building a digital single market, clearly this hasn't worked, right? Clearly that hasn't served its purpose. And I think, correctly, the Commission's view is they want to, in some instances, stop Europe just being a place where people sell their products and instead being the place where they develop their products and they invest their R&D. And that's totally fair, and that's something certainly that Digital Europe is encouraging and what our members do want to do. When you do sort of get into these discussions, and it does get very tricky when you start talking about fundamental rights and sort of how to reach that balance, especially when you start getting close to talking about the fundamental right to data protection and fundamental right of privacy. But at the end of the day, no right is absolute, right? And that says that even in the recitals of the GDPR, it needs to be balanced with all other rights in there: right to free speech, the right to security, the right to run a business, all these things. And what we're seeing, at least, is some of our companies are saying, we have to really make a tough decision after we go through this entire compliance regime. If we want to actually build out a product here in Europe, and maybe we have the best skilled people, and maybe we have the best infrastructure, and all these positive aspects, I have to counterbalance that with the risk that's associated that even if I do my very best to comply, I might trip up somewhere. And if I run into a data protection authority who feels like they want to exercise their right to fine me 4% of my global turnover, that's a pretty tough decision to make for companies. And what we don't want to see happen is companies say, it's not worth the risk, I'm going to create my product or my solution in Asia, in South America, and North America, and then import that product into Europe. We, again, haven't solved the problem of actually building that growth here in Europe. And that's certainly something that we hope is not going to happen with e-privacy. I'm not trying to be over-dramatic to say that e-privacy is going to be the legislation that decides where companies will or will not develop their products. But it's not a stretch to say that it won't play into that actual thought process. The last thing I would say is sort of actually we haven't talked too much in relation to the international transfer issue. One thing that's quite interesting is we keep talking about adequacy and the use of these transfer tools and the risks that are facing them. But we're always talking about it in a one-way discussion, protecting data when it leaves Europe, which is something that we need to do. But we never talk about how can we create data flows coming into Europe to sort of build up the European data processor market. So it's not every time you select a service that the processor and the analytics are being run by a company somewhere else. And it's always focusing on this one-way discussion. That's something that I know Digital Europe members are really interested in, sort of raising awareness that it's a two-way discussion, right? We need to make sure that we actually bring competitiveness into Europe, right? And so when we do have discussions now, as noted in the communication, that we're beginning adequacy negotiations, or even though it's a one-way decision or unilateral decision by the Commission, but it's still a discussion with the Japanese government, for instance. A lot of these other jurisdictions around the world, they have their own form of adequacy, right? And part of that is the negotiating tactic of these other jurisdictions. But instead of only focusing on how can we make sure that the data that leaves Europe is safe in Japan, how can we make sure that we can prove to Japan that we also get an adequacy decision so that data can flow freely from Japan into Europe as well, which is beneficial to the European economy. So it's a little bit of a two-way street here that we need to pay attention to. And then the last thing I would say is, Digital Europe is involved in the case in Ireland, and I don't necessarily want to talk about ongoing litigation due to limitations of what I can and cannot say. But one thing I just want to clarify, which is important, which sometimes gets distorted, and it wasn't mentioned during this panel, but I've heard it so many times here in panel discussions in Brussels, is what the court actually said with Safe Harbor. What it actually said was the Commission didn't do its due diligence properly when it made its assessment of the US legal framework. And because of these allegations of Snowden, and because of the facts that are in front of me as the court, I have enough reasonable doubt to assume that the Commission didn't do a full assessment of US law. So therefore, the actual adequacy decision in and of itself is invalid because it wasn't they basically didn't do their homework. So I think that's what we're also going to be facing. So the Court of Justice didn't make a ruling on if the US legal system is or is not adequate. And it probably won't be doing that again anytime in the future if Privacy Shield does or doesn't come in front of the Court of Justice again. What it will rule on is, did the Commission actually do its homework, and do these mechanisms meet certain standards that exist in the Charter of Fundamental Rights? Not if the US isn't adequate, because the only entity who can do that is the Commission, but they can strike down the way that they go about doing that information.
It's interesting. So I think you just heard about, instead of a balance of trade, a balance of bits. You heard it here first.
Yeah, import and export of regulation is actually, I think when I retire, that will be my PhD thesis. Our experience is that GDPR, because it sets a sort of gold standard, is being implemented by lots of countries in order to obtain data flows. In other pieces of legislation, we've seen in our Latin American entities that national regulators and governments have actually stopped implementing net neutrality regulation fashioned to reflect the EU, and are now looking to America and trying to deregulate because they see that as a competitive change. Anyway, that's an aside. In relation to the e-privacy, we talked a lot about clarity. We talked a lot about consistency. I think the way you described it before as GDPR is the base legislation, and this is the special legislation just for this sector, means that there has to be a link. You can't forget what you did with GDPR and start again. And that's what we see at the moment in the proposal. So we would like to re-establish that link. And then our plea is really leave, there to be some scope for competition and there to be some scope for firms to manage the relationship in a customer-friendly way. That's what we do. That's how we earn money. With all respect, legislators do not understand how to do that, and the cookies legislation is a prime example of how not to deal with the customer experience in legislation.
Over to Jeremy.
Yeah, I would just say that in the context of e-privacy, with so much moving in this space, we just want to make sure that we're coming up with workable solutions for all the reasons that the Commission, I think, would share and all of our customers would share. We'd like legal certainty, we'd like harmonized rules, and we would like, of course, rules that encourage rather than inhibit competition, that encourage rather than inhibit innovation. That's something I don't think too many people disagree with, but when you look at some of the text here, especially when you're looking at texts in a privacy context, GDPR has been cited many times, but there's a proposal floating for digital contracts, which goes at this question of data as a counter-performance. And then we have consultations that are looking at questions around portability in a B2B context and data access. So these are a lot of moving targets, and if you're trying to make sure that you're doing everything by the book, the target keeps changing. So we need a lot of time, I think, to adequately discuss the implication on the wide range of services that are now going to be captured in this new set of obligations. So I think the timeline that was announced by the Commission might be a bit ambitious, and I do hope we have adequate time to land on some workable solutions.
Well, I think I can be very brief. Two comments, really. The first is just to echo the importance of aligning, to the extent possible, the e-privacy regulation with the GDPR here. And, I think of most concern to civil society seems to be the cookie issue and the level of consent, or the standard for consent there, as well as, there's a very anomalous provision on hotspots where for data emitted from particular devices, you just need to have notice of the fact that that data is being collected and processed, rather than, it seems to indicate that consent is not necessary, which is really at odds with everything in the GDPR and also other provisions of the e-privacy regulation. So I'm assuming that won't survive the legislative process. And then the second point, just on the influence, I would agree that, of course, data flows shouldn't be one way. And in many ways here, I think the EU has I think it's a very rare example, if I may, of EU regulatory supremacy, where the EU just had a first mover advantage as a result of the way that the adequacy provisions were structured in the directive. And so as a result, you'll see that it's the EU model for data protection has been the blueprint for data protection models worldwide. And so you very much see kind of a coalescence around the EU standard. And so as a result, I think the adequacy standard still has a lot of influence. Now, I would agree with the point that Schrems, of course, didn't say that the court could determine whether or not a particular country offered an adequate level of protection. But in addition to holding the Commission to to a particular standard of review, I think it's important to emphasise that the court also says that in this context, because the assessment that the Commission is making is one that's based on a fundamental right or fundamental rights. So unlike, for instance, Commission decision-making in the competition law context, where the Commission is afforded a very broad margin of discretion to the complex legal and economic factors, in this context, the court says there's a very strict standard of review. And I think that's also going to be very important going forward. And then just the final point, I think the other side of this coin is, so the EU has kind of managed to have leverage vis-a-vis third countries through this adequacy framework. But on the point that was raised about whether or not startups, etc., might consider moving outside of the EU because of the regulations that are in place, I think the GDPR, and it seems the e-privacy regulation is going in the same direction, have very broad jurisdictional scope of application as well. So if you're offering services or monitoring the behaviour of EU residents, then the GDPR applies to you. Now, all bets are on as to how that will be enforced, but certainly for bigger companies, that means that if you want to go to market in the EU, you still need to respect these rules, whether or not you have a physical presence in the EU. And again, I think we could question whether or not the court's judgments and other movements here are pointing towards EU data localization. I think that was probably, for me, one of the potentially worrying parts of the Tele2 judgment, where the court said that in order to comply with the rights to data protection and privacy, you needed to have the data stored in the EU. And I think that's something that you could really challenge as to whether or not it's a proportionate or necessary for the protection of fundamental rights.
Thank you. Thank you. Thank you very much for a quite fascinating panel. Well, we're at time. In fact, we're right on time, more or less. So with that, I'd like to thank the audience, and I hope the audience will thank the panelists.